So I just wanted to talk about this because this actually, it sets out a basis and it helps support and explain the basis with the right to petition, basically. What's going on with the right to petition? When we're using it, we're seeking a resolution from either House of Parliament. Well, it's actually in particular, specifically the House of Commons. We're seeking a resolution of something, right? Now, I've set out quite a few arguments over the jurisdiction of the courts that is supported by the petition election rules, which sets out that if there are any offences to do with elections petitions, then they've got to be prosecuted at the High Court because it's in connection with petitions to Parliament. But I'd like to look at this. So this is an act that's repealed, okay? But it is the Justices of the Peace Act 1997. So it can only be about Justices of the Peace. It can't only be about MPs or ministers or the Queen or councillors. It's specifically the act is the Justices of the Peace Act 1997. Now we know that council chairmen are effectively Justices of the Peace who only have a commission for being a justice as chairman of the council only and not anywhere else, because it's effectively the same thing, but they've only got the power to make orders for the council, right? So I want you to, this is the Petition of Right and Magna Carta that I've been talking about. So I came across these, right? This is from the Justices of the Peace Act. So it says here, Her Majesty may, by order in council, substitute for any one or more of the areas of specified in London, blah, 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 blah. But I want to concentrate on the first 5 or 6 words of this. Her Majesty may by order in council. So that is when Her Majesty can make an order in council. So making an order is to actually make an order, like a judge makes an order. He writes something out and someone must obey it. Someone must comply with it. When you get a letter from the court, what's a fine? It's like, you must do this. You must obey it. Well, when they write it out, they're creating something from nothing, but they're creating something as per directions in law, because the judgment was made in a court, and then the law says that the judge has to give someone a certain sentence, or has to, like even if they say you're not allowed, like if you get a tag, you're not allowed to go out after 8 o'clock, or if you get an ASBO or antisocial behaviour order, or, something that you've got to comply with, they write an order. But that order it's kind of like, so how it works in government is that you have your legislation, you have the statute laws, and then you have your acts of laws, but then you have statutory instruments, which are, it tells you what a statutory instrument is. And the statutory instrument is by which methods through the legislation certain persons write, or acts of law can get them to write and make statutory instruments and orders. Like, for example, in an act of law where it says, if you do this or that, the judge may make an order for you that you have to, do this, but it tells you in the law what that has to be. Or by statutory instrument, you can exercise power. In the Town and Country Planning Act, when we got deemed an express consent to do something, and we're allowed to do it through use of enactment, the right to petition isn't a statutory instrument, it's an actual law that gives us a right. and provisions of it. But the Town and Country Planning Act is a statutory instrument. It says that statutory instruments are usually exercisable by ministers of the Crown, but also, obviously, this is the Justices of the Peace Act, so it's got to be Justices of the Peace as well. But it's in making an order as well. But the thing is, the thing about the Town and Country Planning Act is an act of law that you and me can use it. You and me can actually use that statutory instrument to make advertisements and place them in public without being liable to be prosecuted by any of the authorities who aren't actually allowed to make an order against us or a statutory instrument, because they would be actually the right to petition actually uniquely prevents us being held to any commitments by statutory instruments or acts of law. That's how it actually works. Now here, so order in council, but this act is about justices of the peace. So it can't only be a magistrate and ministers of the Crown, because it is the Justices of the Peace Act 1997. Now, it has been repealed, but we're looking at it because we're looking at some meanings and some basic fundamental principles in law, framework of law. Now, you'll notice that the Appellate Jurisdiction Act was repealed, and then in 2005, they had the Constitutional Reform Act where they reformed the Constitution, but we still have the Privy Council in place who are in the House of Lords. The Privy Council, are the King, and they have a judicial function of the King. You know, like Ed Davey MP is a member of the Privy Council. All the Right Honourable members are. So the Privy Council, the Privy Council is kind of in a way in between both Houses of Parliament, although it either of the Houses of Parliament or the King himself. It is the King. So, you know, it's the Privy Council really is kind of in between both Houses of Parliament. Let's look at some other provisions from this Act, at the wording of it. It says here, subject to subsection 7.1, a statutory instrument containing civil procedure rules is subject to an annulment in pursuance of a resolution of either House of Parliament. So a resolution, someone who's pursuing a resolution from either House of Parliament. But it doesn't say who. It doesn't say who can pursue a resolution. It doesn't say whom is pursuing a resolution, right? Now, you would think that when you are petitioning the House of Commons, you are seeking a resolution of something, like a grievance. You have a problem. I'm annoyed with this or that. And the problem usually is something that the council or the government have done wrong. So it's actually in relation to a local council authority or the government. Now, the local council authority only exercises functions and makes orders through statutory instruments and making orders, as does Parliament, and the courts make orders and exercise, acts of law into effect and statutory instruments. So it's mentioned in the civil procedure rules here. Now, there's only, as far as I know, there are only one set of civil procedure rules. Only one set, right? Subject a statutory instrument containing, a statutory instrument containing civil procedure rules. Well, surely the civil procedure rules are their own instrument containing civil procedure rules. Surely, because they are the civil procedure rules. Unless you're talking about the Magistrates Court Act, but that's not the civil procedure rules, but it contains law or rules which you might use in civil proceedings. So you could say that the Magistrates Court Act has law or rules in it which are used in civil proceedings. You could say that. Now, the thing is, this is the thing. Once a council or a court or parliament is doing something or has done something, right, we've got a right to oppose that or get it changed. But there are two situations. One situation is when you're appealing something that someone did. And the other is when you're not appealing something they did, but you would like them to do something nonetheless. For example, you want a new set of swings and slides in the park. You're not appealing anything, right? But you're making a request, right? The thing is, the park didn't exist at one point, so someone made an order to put the park there. So there was, at some point, an order made by the council to make a park, even if it was 10 years ago, right? And if you were wanting them to, change the park or get rid of it, then really, in a way, you're appealing something that was, or getting a change to something that was done, 5 years ago. There's not really anything in... If the council if someone's making a load of noise, and you petition the council to make them stop, even, you'd have to petition them. They've got all processes in place. That noise usually came from somewhere. Now, the council have got a role and duty, they've got a noise pollution department anyway that provides a service, right? But the noise might be coming from the council, it might be their noise, or whatever. Apparently you can't complain about building sites, but once the council approved building, this is the thing. Now, according to this, right, any order or statutory instrument or anything that's been exercised with similar or such powers, according to this basis, is subject to an annulment upon pursuing a resolution from either House of Parliament, right? And I don't see why that should not be the Privy Council or from the King either. What this actually is, this has to be the basis of petitioning Parliament for a resolution or petitioning the Council. But this is the Justices of the Peace Act. For Justices of the Peace who are meant to make orders in courts. Or else, the whole act is Justices of the Peace Act. Here's some more. They're all slightly different. Here's one. Subject to subsection 7, a statutory instrument containing civil procedure rules is subject to annulment and pursuance of a resolution of either House of Parliament. Statutory instrument containing altered rules by the Lord Chancellor is of no effect unless approved by a resolution of each House of Parliament day before the day referred to in subsection 3A. The power to make an order under this subsection is exercisable by statutory instrument. The power to make an order. Well, judges make orders. And this is the Justices of the Peace Act. The chairman of the council makes an order when the councillors have voted on it. The powers to make an order under this section in the Act of Justices of the Peace is exercisable by statutory instrument. So that's, as set out in law, by statutory instrument, the power to make an order. A statutory instrument containing such an order is subject to an annulment in pursuance of a resolution of either House of Parliament. So these are all pretty much the same thing with a very slight variation, whether it pertains to civil procedure rules or the Queen making an order in council. But every time it is annulled when we pursue a resolution by either of the Houses of Parliament, the Lords or Commons, right? It seems to me that if you get convicted by a magistrate's court, we would be right to say that an order made by a magistrate's court is subject to annulment in pursuance of a resolution from the Crown Court, or an order made by containing a conviction or an order or sentence, an order made by a Crown Court containing a sentence would be subject to annulment in pursuance of a resolution from the High Court, right? Or with the Appellate Jurisdiction Act, you could say an order by the High Court or a sentence given by the High Court is subject to annulment in pursuance of a resolution from the House of Lords until they repeal the Appellate Jurisdiction Act. But let's not forget the Privy Council exists, and the Privy Council of the King, we have the right to petition the King over anything, still exists in the Constitutional Reform Act 2005. And we got the power to give directions under Schedule 2 as well, let's not forget. And there's also representations to the House of Commons from the judiciary as well. There's some more of these, right? They're all effectively the same thing, but a slight a variant. They're all a slight variant of the same principle. A statutory instrument containing family procedure rules is subject to annulment in pursuance of a resolution of either House of Parliament. Now, the Courts Act 2003, when that Justices of the Peace Act was repealed, this Courts Act 2003, which is not, contains, well, if you search it, the same basis and principle in effect. So even though that other act was annulled, the underlying basis and formula of law and principle is still in legal effect. Another one, statutory instruments containing criminal procedure rules is subject to annulment in pursuance of a resolution of either House of Parliament. So there's a variation of this for civil proceedings, there's a variation for family proceedings and for criminal proceedings. And the act is Justices of the Peace, not the butcher, the baker or the candlestick maker. Justices of the Peace. Well, they're judges who make orders, right? They aren't ministers of the Crown. Why isn't it called the Ministers of the Crown Act? No, it's Justices of the Peace, right? So, it's saying statutory instruments, which is a little bit misleading to most people. But effectively, when a judge makes an order in a court through, if you have, in one of the, when it says in the Criminal Damage Act or, the Highways Act or whatever, it says, it gives, it's law, but they also have statutory instruments. And the judge, this is when judges say, I have to get, I can only give them, 3 months sentence or 30 days sentence, or the sentence can be between a month and 30 days, like a month or 2 months. He says, he's got a certain criteria that he can make an order with, but only according to the law and the statutory instruments that say he might be able to give someone between 200 hours and 20 hours community service, right? He's allowed to make an order out. He makes out the order. Really, that order it's kind of like, you see, they say statutory instruments are secondary legislation. You've got statute law and primary legislation, and then they refer to statutory instruments as secondary legislation. You see, the Town and Country Planning Act 1990, with all the definitions of adverts in it and so forth, that's an act of law. But the 2007 Town and Country Planning Act is made as a statutory instrument, but they've got all the things for placing of notices in there, and the council's issuing fines to people. So the council would issue a fine through that statutory instrument if you put a notice up and you weren't allowed, and they would tell you to remove it. They would be making an order to remove the notice exercised by statutory instrument, and then you might get a fine, you see, if you don't. But I use the statutory instrument 2007 Town and Country Planning when I put up a notice in Class F. I'm executing powers through there, and the powers I execute, I decide that I'm putting a notice up, and I am not liable to conviction or prosecution from another authority, and I am by exercising the 1688 Bill of Rights provisions of that enactment, I use through powers given to me through the statutory instrument. I am exercising the power, and the courts and the council do not have the power or authority to remove the notice. And the police do not have the powers to obliterate it. And they don't have the power to make an order against me. It's illegal, unlawful. So by petitioning, by writing a petition to the government and placing it, I actually am I'm using the statutory instrument. Well, everyone uses the law anyway, but I also can use a statutory instrument. It's a good example between the Town and Country Planning Act 1990, which is only an act of law, and the 2007 Town and Country Planning, which is statutory instrument. So, really, when a judge writes an order out following directions that, within the parameters of which he's allowed to write and make an order into effect, he gives it legal effect through his power. Obviously, when he puts the hammer down, he makes the order. He's making law, you see. These orders from courts you got to, it's a piece of paper that you've got to comply with. Or that, if someone gets planning permission, they write it out that they've approved it. Therefore, you have got legal. It's like a little act, that says, the law is now that you can put this up or do this. If you don't, if you knock something down and you don't have permission, you're meant to get fined, and because you didn't have the legal right or authority. They use a statutory instrument to issue you the fine, right? But the thing is, with this, you've got this criminal procedure rules, civil procedure rules, and family. Well, you've got the civil courts, the criminal courts, and you've got the family courts, and it's the Justices of the Peace Act. So this can't be a Minister of the Crown containing civil procedure rules is subject. So we've got this principle. Now, statutory instruments are usually used by ministers of the Crown in government, right? But local councils exercise powers through statutory instruments as well. And like I said, this is Justices of the Peace Act. Now, the thing is, this act is 1997, right? It's now repealed. But it's before 2005 when they withdrew the Appeal Act Jurisdiction Act. So, at the time this act was made in 1997, we still had the Appeal Act Jurisdiction Act. So you could still petition the House of Lords appeal to the House of Lords against a criminal offence or against a civil order, right? You could appeal to the House of Lords. Now, they still used to have people appealing from Magistrates' Court or County Court up to the High Court or up to the Crown Court and so forth. But you could appeal to the House of Lords, which is one of the Houses of Parliament. So you're seeking a resolution, you're pursuant of a resolution to the House of Lords. And the thing is, right, so look, let's just go back to the basic principle of a magistrate's court. Let's say I get a speeding fine, and let's say I get convicted of speeding at a magistrate's court, right? You could even say that I lose my driving licence. It might not even be 3 points. Let's say you get 12 points, right? And let's say they take my driving licence off me. So if I word it this way, right? So an order and sentence given by a magistrate's court is subject to annulment in pursuit of a resolution from a Crown Court. Can you understand that? So I submit an appeal, I write an appeal to a Crown Court, and as soon as I enter the appeal, right, when I actually enter the appeal and send it, my magistrate's court order is annulled, right? It's suspended or it's just annulled because I'm appealing to a higher court, right? To the Crown Court. And I even can ask for my driving licence back, even though I've been convicted of the offence and an order was made. I tick a little box and I say, I'd like my driving licence back, which you can ask for. And then they send it you back. So the magistrate's court order has been annulled or suspended because pending appeal to the Crown Court, a resolution from the Crown Court. Now, if you get convicted by the Crown Court, you can still appeal to the High Court. So we can say an order and sentence made by a Justice of the Peace in a Crown Court and by Justice of the Peace in a jury in the Crown Court is subject to annulment in pursuant of a resolution in the High Court, right? Well, this has got it for family, criminal and civil, it's got it. So it's saying that any criminal order, basically, or any family order, civil, criminal, or family order, subject to annulment in pursuance by a resolution of either House of Parliament. Well, that would fit the criteria and basis of this, surely, if you were seeking a resolution of the House of Lords by petition and prayer through the Appellate Jurisdiction Act until 2005. So between 1997 and 2005. So 97, 98, 99, 2000, 2001, 2, 3, 4, 5, right? So if it was, the 2000 or 2000, and if it was 1999, right, that would be the case. Now, you might say here, but it doesn't say an order from a judge, though. It says a statutory instrument containing criminal procedure rules. Well, this is the thing. This is the Justices of the Peace Act. And also, you can, even if a minister in government makes a statutory instrument, you can, if you're petitioning Parliament, surely you're opposing that. You're seeking a resolution of it to Parliament. It doesn't say, in this, by the way, it doesn't say who and who cannot seek a resolution. It might be a minister seeking a resolution. It might be an MP, a member of Parliament. It might be a councillor seeking a resolution in the council. Right? We've got the right to petition either House of Parliament for a resolution. So it says that any other order is subject to an annulment. So I'm, you know, we're meant to be able to petition the king over anything. And those standards in the petitions committee are tosh. There are only standing orders 145 and the right to petition. And then there are these statutory instruments like the Town and Country Planning Act and so forth, which we use as well. But what happens if, for example, the ministers scrapped the Town and Country Planning Act or got rid of it? Then we might object to that or oppose it, and we might want them to put it back. So we're pursuant of a resolution over the Town and Country, over the statutory instrument, because the minister did something. Now, does this annulment cover all statutory instruments? If any person is pursuing a resolution from the House of Commons through the Petitions Committee, are all statutory instruments subject to annulment? Well, the Town and Country Planning Act, what the council are using to govern who can and can't put notices, all of any fines that the council could possibly make against you for putting notices up, they're subject to annulment because they can't make them. They ain't got the legal right to. So as the police's illegal police canvassing activities of removing them and obliterating them, that's surely subject to annulment. Or any attempts at arresting you for placing such notices, or any defacement or danger or risk that is left after their removal is subject to annulment, because you're using Class F through the enactment, the right to petition, which is in pursuant of a resolution of either House of Parliament in the first place to start with. Now, I'm starting to wonder that, you know, if a local council makes an order, like for planning, approves a planning, they say that, oh, there's nothing we can do about it, it's too late now. You'll have to get a judicial review or whatever. But I think that's complete utter tosh. I think that you can petition Parliament to the Petitions Committee through the right to petition the King over any subject about anything the council has done, or, because look at Stonehenge Tunnel in Wiltshire, or even the Privy Council and the King. And I think these standards that the Petition Committee have, which don't really exist, you know, there's no laws or rule that exist for it, is a bluff, right? And I think that I'm starting to think that we can petition Parliament over, and that would mean that by actually going onto Parliament website and actually typing in that, you know, we're petitioning against this decision that, you know, Colchester Council made over this planning matter, we are seeking a resolution from the House of Commons. Now, as soon as you submit that and complete the form and submit it, the thing is, you're actually pursuant of the resolution then. You're collecting signatures. Now, the thing is, you've got to get 5 signatures to get it live, and then they've got to check it. And then they're starting to refuse to publish them and call it out on, you know, A, B, or C, whatever excuse of standards. And then you're no longer pursuing it because they pull it down. But There's no rule for that or legislation. There is only the right to petition, which gives you the right. So you are pursuant of it. And if it gets published live, then there's no contest. You're pursuant of it when you're collecting your 5 signatures before they even put it up. That's for sure. Before they even reject it on flimsy terms, right? That would mean that legally, surely, in law, the order which the council have made through statutory instrument, even for a planning being approved, is subject to annulment. Surely, because you're pursuing a resolution from the House of Commons. Surely, even while you are collecting the signatures, and all petitions run for 6 months. But apparently there's no real time limit for that either, unless you law a tampon and you get 8 months because you're doing it on paper, right? So that would automatically cancel any order a council has made for 6 months at least while you're collecting signatures. Like the Huddersfield Town Centre approval of planning, which they're doing on the redevelopment, which they are executing through statute, surely through order of council and by statutory instrument, surely. That means that through the right to petition, I've got the right to petition the council of anything. Screw judicial review. I'm not getting a lawyer or paying a lawyer for anything, because it doesn't need to be decided on point of law. It can be purely on the, opinion of my peers who I collect signatures from. That means that in law, we can go onto Parliament House of Commons petition site and type in the title, we want to cancel Kirklees Council approval of the new town centre development, cultural heart, whatever. And then start collecting signatures for 6 months. And that means that it has to be subject to annulment, surely. Surely it's subject to annulment in pursuant of that. At least until your 6 months run out. Surely. Because you're officially pursuing it. This is law. And I know this 1997 Act is repealed, but mainly because they don't have the Appeal Act Jurisdiction Act for the House of Lords anymore. But you've still got the Privy Council and you've still got the House of Commons. And that 2003 Act, the legal basis and principle is still in effect in this Act. And every single one of these provisions is the exact same thing. It's all the same. All it's doing is doing it for, the same for family, the same for criminal, and yes, the same for civil. Right? And it's a legal basis and principle, like statute law. In fact, is it not the basis of appealing any matter to a high... Is it effectively not saying... I could translate this into a very, very simple layman's terms, which is anything that is being appealed to a higher jurisdiction is subject to annulment. Would that work? Would that fit the description? Anything subject to appeal from a higher authority to a higher authority is subject to annulment in pursuance of that. It has to be. And the final thing is the injunctions that the government or local councils or even Transport for London, which is an authority, but they're not Parliament. You've got the Mayor of London. Now, the Mayor of London, which is Sadiq Khan, the Mayor himself as Mayor of London, who he has a Justice of the Peace power for that commission that he's got to do that job, because you need to exercise powers. He's a Justice of the Peace under the commission of the Mayor of London, right? But only for that, not for the courts, right? Now, when Transport for London, which are an authority, road traffic authority, on contract for the council, like Highways England, but for London, who's seeking the injunction? A company, Transport for London, the Highways England, the chief executive, or is the mayor doing it himself? Well, apparently the mayor cannot be in the court. The mayor for sure isn't allowed to, you can't have Sadiq Khan sat in being a member of the court that is going to decide whether or not they can have a statutory, an injunction or not. The mayor is not have a lawful right to be a member of the court who would issue the statutory instrument. Why do I keep saying that? The mayor does not have a legal right in law to be a member of the court who would issue a injunction, because the council authority is not the court, and someone might object or appeal against the injunction, and therefore you're opposing the mayor. This is why I'm starting to wonder, how it is possible how the mayor or even, like look in America at Stop Cop City with Atlanta, when they're meant to be impartial, how they can even go to the court anyway. But, as people can challenge the council in court, but, there are certain things, when you're petitioning a local authority in council with a petition, and the chair of the council is a justice of the peace on that matter under that commission of authority, why would he be going to a court to challenge you when you're the one bringing a case to him? That seems rather odd to me, which is why I find it rather strange that in America, how are the mayor in America, under the commission of the mayor, and the petition is to him on that matter, why is he going to independent courts to get weird actions when it's under his authority in the first place? Because he's meant to be impartial to what all of the citizens want, for or against. This is why I don't think that Atlanta Council can act as a... they can't take a side in the matter because they're meant to be impartial, otherwise they're influencing the electors. They're doing more than influencing the electors, they're challenging them with a position. But anyway, but I think they're challenging the legitimacy of it, which is almost like the election petition rules 1960. If you challenge the legitimacy of it, but I don't think there's much to challenge. But coming back to England, so with Insulate Britain campaign group, they were blocking roads and sitting in the road. But any police authority can close a road, or if they don't think it's safe, can put a diversion in place or put a road closure. That is meant to be executed by a statutory instrument, or the police can just put cones across the road if there's an incident anyway, but they're an authority, so the police are kind of using powers. In a way, you could say the police are making an order, but they don't make the order like a court, or they don't have to go get a warrant from the council to shut the road. They can just do it because they believe it's in the interests of their casework. There's an incident, so we're going to shut the road, right? Or put cones across it at any time. This is the fine line between making an order for something if you're an authority, or when you've got the right, the law says you can do it. So in the Town and Country Planning Act with the signs and notices, we have got deemed and express consent to place the notices, right? And they don't have the legal right to take them down, destroy them, or stop us. With the road closure, so the police have got the right to put cones across the road and stop traffic if there's an incident, under the same legal principle and basis as we do to put notices up through that statutory instrument of the 2007 Act, because it says we can do it. Now, the thing is, because you're using the use of the enactment on Class F, So that's the question. Does insulate Britain through the use of the 1688 bill and the provisions of that bill? Do they have the right to, close a road if they see that it's fit for purpose? Now, Extinction Rebellion have been doing this. They did this at a roundabout at one of the airports on one of their videos recently. They blocked a roundabout or shut a road. Similarly. So this is the thing. But what's happening now is the police are saying, the council might be seeking to get an injunction against that. But the thing is this. The petition itself being to the House of Commons is a legal action or case, you're appealing, but not for something that there doesn't necessarily need to be a sentence, order, or anything made, or you can appeal for a new park, right? I'm appealing to the council. I'm making an appeal to them for a new park, right? But, what happened to the old one? They made an order to, put a park 5 years ago. Well, now I'm appealing for a new one. There's always something to appeal to, unless there's absolutely nothing there at all whatsoever. The thing with the Appealite Jurisdiction Act is it's a funny one within petitioning Parliament, because you can appeal an order or sentence that was made through the courts, or you can bring your own case of which you're not appealing a conviction or an order or sentence. It's a fresh case, But the thing with bringing a fresh case is you don't need to have anything annulled. There's no, it's not like if you got convicted by a magistrate's court, in pursuant of appeal, resolution to the Crown Court, the order is subject to annulment, right? That definitely is the case. I can tell you that. But if you just come to Parliament and say, we'd like, to introduce a new law on, red widgets, no such law exists yet. There is nothing that needs to be annulled. But you're actually trying to annul, you yourself are trying to annul widgets. So if you want to make red widgets illegal, right? If you want to make red widgets unlawful, right? You are pursuing getting them annulled from legality for everyone around the country. But as it stands, you don't have anything currently to be annulled because you don't have an order or sentence against you. But with the thing about the right to petition, it is the right of the subjects to petition the king, and all prosecutions and commitments for such petitioning are illegal. Well, that is annulling. What it's doing is it's annulling all prosecutions and commitments against you, pursuant of a resolution from the king, right? So, by the right, it is the right of the subjects to petition the king, and all prosecutions and commitments for doing so are illegal. So, pursuant of a resolution from the king or either House of Parliament, all prosecutions and convictions against you are surely subject to annulment. That would fit perfectly with the right to petition. It is the right of the subjects to petition the king, and all prosecutions and commitments for such petitioning are illegal. Pursuant of petition to the king for resolution, or either Houses of Parliament, by petition, all prosecutions and convictions against you are subject to an annulment because they're illegal, right? So surely that should include statutory instruments as well that are pursued by the mayor or Transport for London, or a local council. Surely, pursuant of a resolution to House of Commons, an injunction is subject to annulment unless it is made by the House of Commons. Now, I know that in some of the cases, it's the Secretary of State for Transport who has pursued the statutory instrument, but he has to get it from the courts, either whether it's the Royal Courts of Justice or High Court or Supreme Court. But how would you frame the statement if I framed it like this? What would you say if I said this? Subject to pursuant of a resolution of either Houses of Parliament, an order made by the High Court is subject to annulment. Or subject to pursuant of a resolution by either Houses of Parliament, an order made by the Supreme Court is subject to annulment. What about that one? But what you are saying is that, the Supreme Court's supreme. It's got supremacy. But over what, though? This is the thing. Over the Privy Council, over the King. Can the Supreme Court enact law? Can we go to can the House of Commons get an act of law passed by the Supreme Court? Doesn't need to get passed by the King. Who is the King here? This is the thing. I don't think that Transport for London, a company, a business, or the Mayor of London, who is not a Member of Parliament, I don't think that they can go to a court and get an injunction if you're pursuant of a resolution against the House of Commons to the House of Commons. Surely that injunction is subject to annulment. Unless the ministers get it, but they've got to go to the court to get it. And you see, this law was based on when there was the Appeal Jurisdiction Act. You see, now let's look at the equation of if it was 1997. If it was 1997, and let's say all these political actions were taken off like they are now in quite large numbers, would if you're petitioning the House of Commons, like Insulate Britain, would the Parliament be able to get an injunction from the House of Lords? And would they get it from a committee, from the Privy Council, from the Lord Chief Justice? This is the thing. This is before the Constitutional Reform Act. But the thing is, this is the thing, right? This is the ironic thing. If you're petitioning the House of Commons over something and they get an order from the House of Lords to get an injunction, where would you appeal the injunction to? Where would you object to or appeal the injunction? Well, by petition to the House of Lords, surely. So while you are submitting the petition, and when you submit it, and even if you appeal the injunction, then surely the injunction is subject to annulment while you're appealing it. Surely. If they make an order for an injunction, then if you appeal to the House of Lords in 1998 against the injunction, then pursuant of, while pending having that heard, the appeal against the injunction, then the injunction would be subject to annulment, surely. And at what point, if you are petitioning the House of Commons to get all the houses in England insulated, Why aren't you, petitioning the House of Lords to get them all insulated as well, while you're asking them to remove the injunction? Who's doing what? You petitioning the House of Lords for, getting all the houses in, and if the House of Lords say that, yes, actually, we'll get all the houses insulated, then can they just, rack up some legislation and put it through? Or do they have to then tell the House of Commons, this guy wants some legislation for insulation doing, and then after they've written the legislation up and passed it in the House of Commons, because the House of Lords said they've got to, then put it through back to the House of Lords again. It's like dozy-do. So this is the thing. But either way, with the injunction, the provisions of the right to petition is that you will not be prosecuted as criminal. You will not be recognised as a criminal. You will not be made a criminal or recognised as a criminal, right? And the claim of right in Scotland says that you can't be imprisoned. Now, I don't think that you can be prosecuted. And I think that the basis of it is quite evident simply in the Town and Country Planning Act, which is that, you can put those notices up. It even says even if it leaves an element of risk or danger, after you remove them, even if you leave it in a dangerous state. I mean, you're not liable, anyone else would be liable to fine or prosecution. So, you're not being liable to be branded a criminal, or you're not liable to criminal charges where anyone else would be. That's the basis of it. And if that's the basis and principle, then why is that not the basis of principle for each and every act? Like the Criminal Damage Act and so forth. This is the thing. But then again, what is the actual thing that you're doing? What is it that you're doing? Well, in each and every act, it says take into account, what you're actually, you're putting notices up. It's about the placement of notices, advertisements, models, signs in public. So, the injunction, can they get any? The question is, therefore, would be, I'm not saying, I'm talking about within the context, but I mean, sitting in the road is not murdering someone. The police the police and council act with an iron authority and seem to be able to close a road off whenever they want to, but they don't like it when we do. But yeah, it's not something that is, it would be odd if the council started murdering people or stealing people's cars, although they do take people's cars when they're collecting fine money. But, we're talking about things like placing notices or closing roads. You see, closing a road actually is quite an everyday normal thing if the council or police do it when they want to or when it suits them if there's an incident, right? That's the thing. It's not really it's actually not an out of the ordinary thing. It's actually quite a normal thing. It's only the fact that they're not too keen on it and they don't like it because they think that they're the only authority that can do it when they recognise or identify it needs to be done, right? Now, with the signs and notices, which are clearly provided for in the statutory instruments and Town and Country Planning Act, when this principle is at its utmost, most prominent and clarified manifestation, we've still got Max Hill, the chief Crown Prosecutor of all England, doesn't seem to understand that and completely and blatantly disregards the two complete full acts of law and statutory instrument from existing, which include the terms that define what you're doing and classify it being recognisable as an advertisement, and therefore describe it, undescribe it, undefine it as being damage and the other act that he likes kicking around. So if the Chief Crown Prosecutor can do that, I really don't know what the fuck is going on with extremely high-ranking individuals operating in British government with degrees in law in charge of multiple departments of law operating around England and Wales in responsible positions in authority and, controlling police departments. It's concerning, it's as concerning as, allowing corporate entities to build corporate food empires that are making us unhealthy. But, there's a responsible position in council, slamming the hammer down. This is it. So we've got to the point where even when the acts of law, there's no doubt remaining, there's no question of doubt in law as to what's going on, they're still not recognising it. So therefore, when you have to recognise it through those acts of law, town and country planning, the question is posed, can Transport for London obtain an injunction to stop you from putting notices up around town for a petition when you're using Class F through enactment of law with provisions which say that they can't, it's illegal to prosecution or commitments? The statutory instrument has to be one of those commitments which are forbidden. It has to be. Surely the statutory instrument is a commitment which is forbidden along with being prosecuted, because that act, town and country planning, is the model. That's the fully fleshed out, the fully detailed model for this basis of law. Not only is it a skeleton model, it's completely and fully fleshed out, at least in placing model signs and so forth, and not be liable for it. So I can't see how they can lawfully bring the statutory instrument. And the reason for that is that ultimately, because you're in process of being pursuant of a resolution over a matter to either House of Parliament. So such statutory instrument would be subject to annulment because you can't do it in the first place, surely. So the question is, therefore, with the road closures, do the protesters have a right to close the road? That's the question. Without being liable to be prosecuted, or without being liable for injunctions. And the right to petition alone by itself would say that they do have the right, and there's nothing in Standing Orders of Parliament which says that, they can't. But unless any act of law or other statutory instrument said otherwise, like the Highways Act, it says people can't, there are certain laws the police are saying that you can and can't do. But the thing is, the police can close roads if they deem, for safety reasons. So the police aren't getting a warrant from the court, and they're not to close the road. The police have got, merely by being a police officer, they're closing the road, based on their judgment of, whether they think it's safe or not. And I've been on the motorway multiple times, I've been on the motorway when there's been an incident on the hard shoulder or whatever, and there's nothing on the motorway. And then you get that police guy, driving in the car with the lights flashing. No one can go past me, with like 4 or 5 lanes of motorway completely clear. And he's got everyone down to 20 mile an hour, which he could be there for an hour while they're cleaning something up, which might not even be taking, only the hard shoulder up and not even any lanes. But he's got the power to do that. Why? It purely on, the opinion, because I think that it's safe. No, I'll let you pass. Did he just, contact the judge? Oh, it's, Gregory Perrins, they've been here 5 minutes now. Can you make an order to open the road back up again, Gregory? This is it. He's not making an order in fucking court, is he? This is the problem. But Extinction Rebellion seem to be doing it. I can't see. It seems to me that the immunity from being liable to be imprisoned or prosecuted seems to come together hand in hand with the inability to make a statutory injunction. You can't bring an injunction against people putting notices up, and you can't prosecute them. Now, would the government have been able to do that act without all those provisions in? The question comes down to, really, did the Parliament, would it have been possible in law for them to not give people the right to place model signs and notices in public with deemed and express consent? Or did they have to do it because of the 1688 Bill of Rights, right to petition, and to make sure that it's compatible and to not be in conflict with it? Because then you've created a conflict in law. That is the question. And I don't think that they would have been able to enact the act without that. And this is when we're getting into all this stuff with Rishi Sunak and Priti Patel with their, the new acts of law that they're making. I've just forgotten now what it's called. Not Criminal Justice Act. Basically, all this stuff out, all these things outside abortion clinics and locking onto things and, messing with government infrastructure and so forth, But those are the public order bill, that's it. But the public order bill doesn't officially, in the wording of those provisions and the legislation and rules that it's setting out, it's not saying that in this instance or that instance or the other instance that we're encountering people who are engaged in petitioning government and pursuant of a resolution of either House of Parliament. Because surely if they were, any statutory instruments put into effect through the Act would be subject to annulment, surely. They've written that Act as if you're not pursuant to a resolution of either House of Parliament, you're just a odd job walking down the road, or what they call protester or a demonstrator. These terms are rather strange, because then, you're not a petitioner in pursuit of a resolution of either House of Parliament, You're just a protester. It's almost like saying that, a public consultation is not a petition. It's that's what it really is. And it's like, saying that, what we're doing in the council chamber is not democracy. Okay, let's do a bit of democracy now. No, we're doing business. Well, this isn't business, what you're selling. No, let's do a bit of democracy. Oh, we're doing a bit of democracy now in council. No, we call it business now. He's the chairman. No, I'm a justice of the peace. No, you're not. You're a chairman. No, I'm a justice of the peace. No, you're a chairman. This is the thing. It's, protester, demonstrator, or are you petitioning the Crown in pursuit of resolution of your House of Commons? In which case, all these orders will be subject to annulment. This is the thing. Well, they're messing with the definitions and words and terms. So I'm not, I'm questioning these injunctions that they're toying with, whether they're legal or not, and to what extent they can have effect, and then if you can even have them or not. And surely, if you are, petitioning the House of Commons for resolution, or even the Lords, whatever, surely the injunction should be annulled until the results of the resolution that you're seeking, which would be the debate. Wouldn't the, whether the, surely the injunction should be subject to annulment. I don't like these annulments in connection with House of Commons. It doesn't, injunctions are things for businesses and companies and so forth. Civil disputes or one court against another court, but among the Crown magistrates, civil high courts of justice, they don't, to me, seem things for Parliament. But you may disagree with me. If it's subject to annulment and pursuant of, then surely, when does it get heard then? Well, it gets heard when it gets debated, doesn't it? Unless they've got various, committees dealing with it. But when is the resolution? Is the injunction a resolution? And if it is, do they have the debate at the same time that they decide that they should have an injunction? This is the thing. And then the local council building and planning, I definitely think that you can petition Parliament. And surely, if so, those orders should be annulled. Which means that, this Colchester Council Watch could actually petition Parliament over some of the matters in the council, and those orders should be annulled, depending on how many signatures you can get. I really think they need to appoint more committees in Parliament. I don't think we're getting as value for money, particularly when we've got all these Lords in the House of Lords, all these extra House of Lords members. We're not getting good value for money at all. But the thing is, why would you need to petition Parliament anyway? If you got, this is the thing. This is why I'm saying, in the last video, the war, all you need to do is get, 600 or 700 signatures in your ward, and you should have a referendum. It's £800, That's less than what some of the applicants are spending on bringing the case, and they're laying out the money to bring the case to the council because they really want to build something. But we're the ones who were, we're the ones facing the consequences when we're not having, objections upheld. So it should go to public vote. So these are the things that I want this Colchester Council Watch to take into consideration. But also for our council as well, when it comes to this town centre, I think we've got a legal right to petition, because how did they do that Stonehenge one? Because it's in Wiltshire. And if it's over land governance in Wiltshire and land status, why wasn't it put to Wiltshire Council? Why did they have a debate on Parliament in that? Probably because they didn't want it to go to referendum in Wiltshire. So there's a fundamental principle going on here that is, I don't actually think that it's that difficult to get the